Okay, so corporations, this is part one. We're going to start with the business judgment rule, which of course also applies to agency, partnerships, and LLCs. The business judgment rule operates as a presumption. Courts will generally defer to the business judgment of the corporation because it presumes directors are acting in good faith and with the best interests of the corporation in mind. Why is this important? Because it shields directors from personal liability. So the business judgment rule, let's try to repeat that. The courts will defer to, that's right, the sound business judgment of the corporation. The business judgment rule operates as what? That's right, a presumption, and it presumes what? That the directors are acting in good faith and with the best interests of the corporation in mind. And what does this have the effect of doing? That's right, shielding the directors from liability. All right, so if we're going to overcome the business judgment rule, we need a showing of bad faith. Once a shareholder shows bad faith on the part of the corporation, the burden shifts to the corporation to show entire fairness. So you need a showing of bad faith, and that will overcome the business judgment rule presumption. Okay, let's put that a different way. The burden is on the challenger to overcome the business judgment rule through a showing of bad faith. After that, the burden shifts to the corporation to show entire fairness. Okay, so let's try to repeat that. The burden is on who? That's right, the challenger, to overcome what? The presumption through a showing of, that's right, bad faith. And then the burden shifts to the corporation to show, that's right, entire fairness. Okay, so remember, a bad outcome, drop in stock prices, failure to declare a dividend, that doesn't equal lack of good faith. What is bad faith? Fraud, illegality, conflict of interest, self-dealing. We're going to get to those in a minute. Okay, but first of all, let's talk about a couple of things. When you start an essay, always state the source of law. And in this case, it's the Model Corporations Business Act, MBCA. Okay, so corporations, we're going to come back and talk about articles of incorporation, bylaws, and constitutional rights, but we're going to go on with the business judgment rule. That leads us to our next topic, which is piercing the corporate veil. All right, so corporations exist to protect individuals from liability. So piercing the corporate veil is an extraordinary action to hold a corporation's shareholders or directors personally liable for corporate actions. So when can this happen? When there is our two-pronged test, unity of interest and ownership, and sanction fraud or promote injustice. So this is our Sealand versus Pepper test. So unity of interest and ownership, commingling personal and corporate assets, not following the corporate formalities, no distinction between the owners and the entity, and sanctioning fraud or promoting injustice. Okay, this would be for a larger corporation, mishandling corporate funds for fraudulent schemes or unjust enrichment. Okay, so piercing the corporate veil, holding the shareholders and directors personally liable for the corporation's actions or debts. It's never enough that a corporation just can't pay its debts. It's never enough that there's just an unsatisfied judgment or disagreement with the corporate decision. We need some sort of liability. Okay, so a series of corporate entities can be treated as a single enterprise for the purposes of liability, but our two prongs here are unity of interest and ownership and sanction fraud or promote injustice. Okay, moving on to interested director transactions and business opportunities. Okay, An interested director transaction is usually a violation of the duty of loyalty unless all material facts are disclosed or known to the board and authorized by a majority of the disinterested directors, and the transaction is entirely fair to the corporation. So it can also be approved by a vote of the stockholders. But, all right, so let's just say up front that an interested director transaction is usually a violation of the business judgment rule. But we have some safe harbor if all material facts are disclosed or, that's right, known, authorized by a majority of the who? That's right, the disinterested directors, and it is entirely fair, that's right, to the corporation. And it also may be approved in good faith by a vote of whom? That's right, the stockholder. Okay, so what's our test for whether a corporation could have taken that opportunity for its own? Interest or expectancy? Interest or expectancy. If the corporation has an interest or expectancy in the opportunity, then it's probably in conflict of interest. Okay, and we're going to look to our three-pronged test here. Is it everything disclosed or known, approved by a majority of the disinterested directors, entirely fair to the corporation, or approved in good faith by a vote of the stockholders? So interest or expectancy. Okay, so moving on to derivative suits. So, of course, a derivative suit is the shareholders are suing to protect the interests of the corporation, alleging harm to the corporation. Recovery goes to who? Oh, yes, the corporation. Okay, and who's the burden on? On the shareholders to show what? Bad faith. So the shareholders have to allege facts sufficient to create a reasonable doubt that the directors acted in good faith. So in other words, the shareholders, it's their burden to show bad faith. Okay, so in a derivative action, the shareholder demand requirement is that you have to make demand on the board to enforce a right or seek a recovery. Enforce a right or seek a recovery that belongs to the corporation. Okay, the demand requirement, what's our legal standard? Enforce a right or seek a recovery that belongs to the corporation. So they have to show that the directors refused to enforce that right or seek a recovery. In other words, the director's refusal was wrongful. Okay, so demand futility. So the shareholders must show the demand on the board was futile. It was futile. So the shareholders bring an action to enforce the right or seek a recovery that belongs to the corporation. You're going to make demand on the corporation. The directors refuse. The refusal is wrongful. Why would their refusal be wrongful? Well, there's going to be a substantial question of director independence, of bias, improper conduct, fraud, et cetera, et cetera. Okay, so let's go over that again. Shareholder derivative action, protecting the interests of the corporation. The shareholder demand requirement, shareholders are demanding the corporation to bring an action to enforce a right or seek a recovery that belongs to the corporation. They have to show the director's refusal was wrongful, and the shareholders must show demand was futile, meaning Directors weren't independent. Directors were biased, improper conduct, fraud, etc. Okay. So the demand requirement. So when we talk about director independence, what does that mean? The director would receive a material personal benefit. The director lacks independence from another person who received a material benefit, or the director would, or the corporation would face a substantial likelihood of liability. Okay, so the demand board, are the directors receiving a material, that's right, personal benefit? Would they face a substantial likelihood of, that's right, liability? Or do they lack, that's right, independence from another person?